الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وعلى آله وصحبه أجمعين. Um, it's really always very sad and tragic time when we are looking at what's happening to our brothers and sisters around the world, especially in Gaza and in Lebanon. The destruction, the death, the displacement. And whilst this is going on, and our hearts are with our brothers and sisters, and we're doing our utmost to help and to look for activities and initiatives to bring about peace, bring about ceasefire, and bring about a lasting and just peace. We still have to keep abreast of the changes that are taking place around us. And some of these changes are so important that they actually do help to give us more time to be able to address those pressing issues. And one of these changes is what we are going to discuss today with our dear brother, Dr Abulkhair Jalaludin. For those who do not know Arabic, Abulkhair means the father of goodness. And Jalaluddin also has a beautiful meaning. It's like the majesty of the faith. So the father of goodness with the majesty of faith is with us today. Welcome, Brother Jalal, Dr. Jalal. Jazakumullah khairan for taking the time to do the research on this important topic that will give everybody more time to do what is important, not just work, but also have time for family and some rest and recuperation. I was just hoping that to begin the program, that if you would give us an explanation of this right to disconnect legislation. What is the legislation? What is its background? When it was introduced? Why it was introduced? If you would kindly give myself and all the viewers an explanation so that we can have a better understanding.
Thank you very much, Brother Keysar. As usual, it's good to have a conversation with you on important topics. So tonight we are discussing right to disconnect law. And as a background, we know that there is a rise of remote working arrangement. We also know that there are enormous advances in digital technologies. So this developments is creating a bit of issues in terms of people's working life, because people's working life has a professional side of it, and it also has private side of it. So now these developments is blurring, if you like, these lines of different aspects of our life. So this law was enacted to set up some, if you like, boundaries for employees and employers so that they know when to work, so to speak, and when to disconnect from the work. So now, if we look at the thrust of this legislation, then we find that the main issue is from 26th of August 2024, Australian employees who are working for employers who employ over 15 people, not every employer in the country as yet. The employers employing over 15 people, they have a legal right to ignore all work-related communications outside their working hours when it is deemed reasonable. So now, as I said, at the moment is for the large market, large businesses. And from 26th of August 2025, next year, this right will be given to all employees working for employers employing 15 or less people. So what it means in a nutshell is that if your boss calls you after working hours, then you have a legal right to ignore it if it is deemed reasonable. Yes, so that is the main thrust of the law. Thank you.
Who decides what's reasonable?
So reasonableness is something we need to understand to comply with this law. So now, how do we know, as we ask, is what decides on that? So for that matter, if we look at the legislation itself, we find that this term is not defined. The term reasonable is not defined in the law. And we also find that the Fair Work Commission, which is the agency responsible to administer this law, they haven't yet issued any determination in terms of how to comply with this law. And that determination might also have a definition for this term. We don't have that as yet. So it is an established legal practice that if a term is not defined in the relevant legislation, then we look at various established dictionaries. And in Australia, one of the reliable and established dictionaries is Macquarie Dictionary. So Macquarie Dictionary has a definition for this, and this Macquarie Dictionary defines the term reasonable as something which is agreeable to reason, or something which is agreeable to sound judgment, or something not exceeding the limit prescribed by reason, or something which is moderate or moderate in price. So this is the definition and dimension of definition we find in Macquarie Dictionary. So in terms of this law, this definition could be acceptable to determine circumstances whereby right to disconnect is reasonable or not reasonable. So that is how, at the moment, we can understand what is reasonable and what is not. Maybe later on we can discuss a bit further how it plays out in our real life. Thank you.
Well, it's going to be very interesting, especially if an employee decides to implement these boundaries. Some bosses feel that they have godlike powers where they can treat the employee as if he or she is there to do whatever they like. So it'll be very interesting when this is tested, and quite often you see that also at the level of lawmaking. For example, many politicians call on their staff at all hours when they're under pressure. When there's an issue that pertains to them, sometimes they expect their employees to work around the clock, and they are the ones who had to vote on this law. So this will be very, very interesting. I'm sure many people can relate. Many people would have worked in situations where their bosses were calling on them at very unreasonable times. And one thing that the bosses don't realize is that the employee is a human being, flesh and blood. That they need time for their family, they need time to do their shopping, they need time to rest and recuperate. If you don't rest and recuperate, then you're going to make errors in your work. There is no way around that. If the worker is not well rested, then there will be errors. I think this type of law is just as good for the employer as it is for the employee, and these boundaries are very, very important. But I think we need to see the first test in court to see how our court system is going to look at this new legislation and how to implement it, and how many definitions the government will have to introduce to make sure that the spirit of this law is actually enforced. The next question that I have for you is that what does this right to disconnect really mean in real life for an employee, for a man or a woman who has a job and they need the income to, they might have a mortgage, they might have all these other demands on them. How does this law help them? What does it mean for them?
Yes, definitely. To comply with this law again, a number of phrases in the legislation needs to be understood, and one of them is this: right to disconnect. As you mentioned, that people have important aspects of life outside their professional life, then how do they know what does this right to disconnect exactly mean in their real life? So in legislation, right to disconnect means that outside your working hours, and whatever is your working hours, it could be 9 to 5, it could be a shift in the day or during the night, whatever is defined with your employer to be your working hours. So outside that working hours, you have a right, I would say a legal right, to refuse to monitor, to read, to respond to contacts or attempted contacts from your employer. And it could also be someone other than your employer if that contact is related to your work, including contacts from your clients. And it could be that contacts from general public, if the role is a public role. So therefore, it is a broad thing that you can avoid disturbances to enjoy your personal life, and if it is deemed to be reasonable, then you may not spend time reading emails and responding to phone calls and things like that. You can just ignore them, and in that, the key element is your refusal needs to be deemed to be reasonable. Thank you.
So this law does not mean that an employer can never call an employee after hours. It just means that they have to put some limits to disturbance that they cause to their employee. Would that be a fair statement?
Yes, yes. So now, if you look at the right to disconnect, that might have a connotation, or some people might understand that yeah, okay, from now onwards, nobody can contact me after working hours. Actually, if you look at the legislation, no, definitely not, because the right to disconnect legislation will not restrict employers or managers, if you like, to contact their employees whenever they wish. Because there could be situations whereby they have to contact. It could be a life or death matter, or it could be many other reasons why they have to contact you. So therefore, the law does not bar them to contact their employees. But this law gives a right to the employees to ignore contacts, means that they don't have to follow communications. It could be a telephone call, email, messages, or emojis. Because I was told, somebody told me that an employer send an emoji, which will mean that you have to do something. So they can ignore all these things outside their working hours unless this refusal is deemed to be unreasonable. So therefore, what it says is you can refuse that if it is deemed to be reasonable. That is what you need to know that, and you can carry on with your life outside work, but you just need to be careful about these limitations.
So based on that, if there's a major event that is going to impact on the organization, then that would be it would be unreasonable to refuse. If it's like you say, if it's a life or death matter, it would be unreasonable to refuse.
Yes.
But any minor issues, if the employer should not be calling you to ask you what the weather is, they can find out on their own after hours. They can't call you to ask you if you watching the news or what you think of it. They can do that in work time. That would be a fair statement. It's sometimes there are some employers that become so dependent on their employees that they can't seem to do anything on their own. So if you get to a situation where an employee does disconnect, what is the dispute resolution process? If the employer says, no, you had no right, you should be responding, and starts nagging like as some employers do, and start playing the narcissist dependent card, and then the matter escalates to a dispute between employer and employee. What is the dispute resolution process in that situation?
Thank you for the question. Can I just clarify a bit more before we get into the dispute resolution? I just want to have a bit more clarification in relation to what is unreasonable refusal, because we have been saying that you can ignore employer's request unless it is unreasonable. So what is that unreasonable request? Maybe a bit on that, and then we'll come to
certainly
the resolution.
That's good. Certainly.
Yeah. So now, what is unreasonable? On that, if, for example, if the contract is legal or the contract is covered by a law, then refusal to that contract will be unreasonable. I give you an example for that. Say a doctor or medical professional is on call in relation to a situation, for example. So for this doctor to refuse to monitor, read, or respond to a contact from the hospital or an attempted contact will be deemed unreasonable. On the other hand, if the contact from your employer is not covered by a law, then it might be reasonable for you to refuse that request, but not necessarily. It might be, but not necessarily. To decide whether your right to disconnect is reasonable, you need to look at some factors. And those factors are given in the law. Nobody is making them up. So it is very important that if you are going to refuse this contact, then you need to have a look at those contacts. And I understand that it is hard for a general employee to have a look at this law and then have a look at these factors and decide. But even then, that is the law is, and that is what the law is, and you need to look at that. So I'll just very briefly just mention those factors. The factors are the reason for contact, how the contact is made, how much disruption the contact causes the employee. Means the contact could be once in a blue moon, once in 6 months, or once in a year. And there could be a reason why the employer is contacting you. So you shouldn't ignore that. And that ignorance might be unreasonable. Any compensation the employee receives to be available to work when the contact is made or to work outside their ordinary hours. Again, if you are paid to work after your working hours, or if your contract stipulates that you might be working after your working hours, then it will be unreasonable for you to refuse that contract. The employee's role and their level of responsibility, very important factor you need to look at. What type of role you play in your organization. The employee's role and their level of responsibility. The last factor is the employee's personal circumstances, including family and or parenting responsibilities. For example, if someone is sick in your family, or if you are caring for your parents who are sick or they need care, then it might be reasonable for you to refuse. So now, before you refuse, you need to look at that. And this is what it means is, it is very important that we analyze these factors before we refuse a contract from the employer. So now if we look at, there could be issues because there are, as Brother Keysar, you mentioned, it is complex. There could be issues. So there could be disputes. So what is the resolution? What is the resolution process in here? according to this legislation, at the first instance, if a dispute arises between the employee and the employer in relation to this right to disconnect, then this dispute should be discussed and resolved at the workplace level. So this is a requirement in the law. It is not an option. You need to discuss if you have an issue with your manager or with your director, whosoever you report to, you need to discuss with them first. Then the law says that if that is not achieved, or if it is not achievable, because there could be many reasons why it is not achieved or achievable, then an employer or an employee, because there could be issues on both sides. An employee might say that I have right to disconnect, or my refusal is reasonable. On the other hand, an employer might say that you do not have a right to disconnect, or the reason for your refusing, that is unreasonable. So it could be from both sides. So both sides can lodge a report with Fair Work Commission to deal with this matter. So how to lodge a report and complaint? There are processes and procedures which are found in their website. Thank you very much.
So at this stage, it is at the Fair Work Commission, but the Fair Work Commission can only look at situations where the employee's salary is below a certain amount of money, unless the employer agrees for them to look into it. So there will be situations where somebody who's a high income earner who is being hounded by a new boss who does not respect boundaries, and the boss refuses for it to be heard at the Fair Work Commission, the next option would be to go to court, I suppose. Would that be a fair statement?
Yes, you are right. Well, Fair Work Commission mainly looks at the salary and wages issues, but this law gives them another responsibility, because the government made Fair Work Commission because this is an industrial law related issue. That's why now they have this responsibility to look at what is reasonable, what is not reasonable, what is right to disconnect, and so on. And definitely that is a normal process of law. If Fair Work Commission cannot resolve that, then there are many other legal avenues for the employee or the employer concerned to further pursue the matter. Yes.
So are you aware of any other country that has adopted this right to disconnect law for their citizens, or is Australia the leader in this area?
Yes. There are countries in the developed world as well as in the developing world who have enacted such laws to protect people's right and improve their working and personal life situations. In the developed world, French is the pioneer in this space. French has enacted such laws in 2016. Other countries who enacted this type of laws include Belgium, Italy, Luxembourg, Spain, Slovakia, Argentina, Chile, Mexico, Ireland, and the Philippines. So now, one thing is, coming to my mind is, if I look at this list, I don't see any Muslim countries in them. But the matter is, in Islam, there is a large emphasis on haq, on rights of people. And I haven't seen this in this type of law any in Muslim countries. So maybe Muslim countries can have a look at this as a model and see how to protect people's right, which is also emphasized by our religion. So
well,
yep, go ahead. Thank you.
We have many teachings about being just, especially to those who are in a weaker negotiating position. For example, the verse where Allah Ta'ala says that He commands that we behave justly. Justice, إن الله يأمر بالعدل والإحسان. Justice and excelling in the way you deal with other people, treat people in a manner of excellence. We have a hadith of our Prophet ﷺ to make sure that the worker is compensated before his perspiration dries, which means that pay him straight away. And under the Islamic principles, if you are going to if you have agreed to set certain work hours and employees working on the basis of those working hours, then if you use their services outside those working hours, regardless of their position, then you're supposed to compensate them. And this compensation can be either by way of taking time in lieu or by paying them for that extra work. This is their haqq. We talk about what is a person's right. This is the right of the employee, and the employer has the right for the employee to work faithfully and honestly and loyally and sincerely and to the best of their ability. But I think with all the changes around the world, these Islamic principles will need to be codified into law, and it would be very beneficial if they were codified in a way that truly reflects the Quran and the Sunnah. And maybe, as you have done some work in some Muslim countries, that those countries might take the lead if the debate was to get started in those countries. They might start to take the lead in the Muslim world of making sure that workers' rights are protected. Inshallah, I hope that, I pray to Allah subhanahu wa ta'ala that this conversation will reach and it will get the other people to sit up and take notice. I think we've covered many very important areas with respect to these laws, and I just want to ask Dr. Jalal if you have any final comments or last words on this new law and its implementation in the workplace.
Yes. Yes. The first few comments about the implementation of this law. If you look at it, the details around reasonableness and the details around right to disconnect are yet to be worked out. And as we mentioned before, that Fair Work Commission hasn't issued anything in relation to that. And my understanding is they may not, because at this stage, because the law just came in August, at this stage, if they were to issue a determination, then they will be saying pretty much what we have just said, which is basically the theory and law part of it. They haven't got any cases and any rulings from the court system. So therefore, they may not issue that. So because these things are not defined, the industries, in fact, they are grappling with these uncertainties. And these are uncertainties because these things will depend on individual employee circumstances. Unless these are tested in a court of law, then we don't really know what it is. That's why maybe there will be some cases in the court system or even in Fair Work Commission. Then those cases might provide some clarity and principles for the implementation of this law. There could be that Fair Work Commission would select and fund some cases just to have a verdict from the judges. And once that verdict comes in, then that will provide principles which Fair Work Commission can adopt to implement this law. And another part of this law is, this law in fact created a brand new right for Australian employees, which is a good thing. And because previously we didn't have this law. Previously, as Brother Keysar, you mentioned that, people were not having rest because there are reports that employees couldn't sleep and so on. So we have this right now to protect ourselves. And the other thing is, this law is an opportunity for Australian employees to take control of their work-life balance. They can improve that part now and focus on other things in life which matter to them. Similar to this law may also pave the way to claim compensation for unpaid overtime. In Australia, there are surveys. There are a number of industries whereby up to 30% of the working hours are done but not paid.
30%.
And yeah, up to 30%. And these are mainly after-hour industries. So now this law might provide some basis whereby they might claim compensation for the work they do.
I know in my last full-time job, there were many days where I was putting 16 hours a day and no extra pay, hardly any recognition. When it was necessary, I would put in the hours without question, but the employer didn't really care. They just expect, no matter how much you offer, they think that they deserve more. They think that it's their skill that's making you do the work, not your passion for the work, not your care for the organization. And it is really this type of attitude that we need to protect workers against. But I was just thinking that another question came to mind as you were speaking and as you were making that last comment. And that question is that whether you know of any submissions from the business community opposing this law or asking for more privileges for the employers. Were you aware of any of the submissions that might have been made from the business bodies?
Yes. In the normal process of framing this law and writing the bill and presenting to the to the parliament, what happened was there was some consultation with the employer groups, especially the unions and the employer groups and the employees, and in relation to employees, especially the unions. And there were a number of submissions for this, and mostly, in my understanding, they were taken care of, and the issues related to reasonableness and also right to disconnect, there were a lot of discussion on that, and for practical reasons, they were left as they are, because unless they are tested in the court of law, we wouldn't know that. And that is why that part is still, so to speak, undefined. And another thing I will just mention, because this is interesting question you raised, Brother Keysar. Another impetus behind the enactment of this law is there were a number of industrial relations changes when this new Labour government came. New means this Labour government came into power. And during the election process, they were promising those industrial laws issues. And when they were enacting them, then they had to consult with other parties in the normal process of business. And some other parties, the Greens and other parties, they had a demand of this law, in fact. They were saying that, okay, if you are going to do that, if you want us to pass that law, then can we have a law whereby Australian employees will have a right to disconnect from work? So that is where it was also accelerated. Then and now it is a law, as we said. The law is effective from 26th of August 2016, and for small businesses it will be 26th of August 2025. The first one is for 2024, and for small businesses, it will be 26th of August 2025, which is next year. I just like to pick up the comment you made, Brother Keysar, before that you did work, and then days you worked more, and so on. And that is nothing new in Australian industries. So what will happen is, in the context of this law, is if someone is subject to do that type of work, then they might find out few things. They might find out what is their normal working hours. Then they might find out whether that extra hours were within that or not. If not, they might have to work out whether it would be, or it would have been reasonable for them to refuse that contact or request to do extra work. If it was reasonable for them not to work, then that might pave the way to seek compensation, because by law they were not supposed to work that period of time, and a compensation might be due on that basis. So thank you very much. Thank you. Yep.
Thank you, Brother Jalal. You've done a lot of research on this and presented a lot of very useful information to myself and also to the viewers. As usual, I will pass this on to the Voice of Islam Radio, where more people can benefit from this conversation, inshallah. I just hope that people who are listening or who are viewing will also pass it on to family members and friends who might be complaining about work, or who look tired, or who look like they're being exploited at work. Sometimes people don't know how to draw their own boundaries, and they need to be supported. They need to be helped. Not everybody goes into the workforce with full knowledge of their rights. So I do hope that people share it around, and hopefully people will benefit from it, inshallah. And I'm really very grateful that you did all this research and were able to have this conversation and explain all these very important changes to all our viewers. Jazakumullah khairan, and Jazakumullah khairan to all the viewers, and thank you all very much. And we conclude tonight's conversation with Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh, and thank you very much for the conversation.
Okay, we stopped the live streaming.